I want to talk a little bit about what's happened at the Department of Justice. There's an office there called the Office of Professional Responsibility. It completed its report on you and Bybee in July of 2009. Their reports didn't become public until February of 2010. They wanted to refer both you and Bybee to their bar associations. They said you had violated his duty to exercise independent legal judgment and render thorough, objective, and candid legal advice. They said Mr. Bybee had acted in reckless disregard of his duty to exercise independent legal judgment and render thorough, objective, and candid legal advice. The OPR report went off to a guy named David Margolis, who's an associate deputy minister in the Department of Justice. He wrote a 69-page report and said, I'm not going to allow the OPR report to go out. It's not going to the bar associations. I don't agree with it. So that's basically where things stand. His report took a little while to come out. I don't know what's happening with the Pennsylvania bar, which is where you is licensed to practice, and in the DC bar. I think there's a possibility somebody can still bring a complaint to the bar association, but I don't know where things stand. You is now teaching law, or back teaching law, at the Berkeley Law School in California. And as I said, Mr. Bybee is a federal court judge. How much time do I have left? None? 12. I have 13 minutes left?
Yeah.
That's...
I think about 10.
Okay. I want to read a couple more things, and then I'll be finished. One is one of the authors whose stuff I've read is a guy named Scott Horton, who works both for Harper's Magazine and is at Columbia Law School. And he wrote an article called When Lawyers Are Criminals. And he wrote it in 2006, and it was about a lawyer named Helmut James von Moltke. And you'll hear what he did. And I'm quoting from Mr. Horton. He was a man whose powerful moral example serves as a model for all of us today, a man who represents the ethical pinnacle of our profession. Excuse me. He was a staff lawyer at the German Defense Ministry during the Second World War. His tenacious advocacy of the Geneva and Hague Conventions in the face of withering criticism and suspicion from the Nazi hierarchy saved the lives of thousands of civilians and prisoners, particularly on the Eastern Front and in the Balkans. It also led inexorably to his execution at the hands of the Nazis in 1945. I'm sorry, and I'm still quoting from Mr. Horton. Disgusted by an atmosphere in which the law was constantly subverted to political expedience, Moltke envisioned harsh prosecutions of politicians and lawyers who engaged in such antics as essentially purgative. In a draft dated June 14, 1943, Moltke envisioned a special international criminal tribunal to be convened at the conclusion of the Second World War for the purposes of bringing to justice those who violated the laws of war. Lest there be any doubt, it was principally the men he worked with every day in the Wehrmacht whose punishment he foresaw. In view of the mounting evidence of the crime of genocide, and out of concern that the international customary law failed to provide a medium for its punishment, he advocated an expansive posture for prosecution. Any person who violates the essential principles of divine or natural law, of international law, or of international customary law in such a fashion that makes clear that he contemptuously disregards the binding nature of such laws shall be punished, Moltke wrote in a plan for the post-war tribunal in 1943. In Nuremberg, there were trials of lawyers and judges in cases known as the Justice Case. 3 of the German government lawyers were convicted, sentenced to 10 years in jail, less time served. When the Obama administration first came into office, there was talk about prosecuting or possible criminal charges against you and Bybee and other senior administration officials for their roles in authorizing torture. Such talk has disappeared in the United States. I want to finish this talk, and I want to tell you a little story. I've been talking about lawyers whose works I don't like. I want to talk about one who I actually like very much. This guy used to be named Lieutenant Commander Charles Swift. He was a military defense lawyer. He was to defend people at Guantanamo. He was assigned to defend a Guantanamo detainee named Salim Ahmed Hamdan, who was a citizen of Yemen and a bodyguard and chauffeur for Osama bin Laden. Lieutenant Commander Swift was told he could negotiate a plea for Hamdan, and he said to them, "It's not my job. I'm not supposed to be negotiating pleas. This whole process, the military commissions are unlawful. I'm going to bring a habeas corpus application on behalf of Hamdan." And he did that. He brought the application, which was ultimately successful in the Supreme Court of the United States. And after the decision, he was quoted as saying, and I rather like this quote, "This means they can't scare us out of who we are, and that's a victory, folks." Mr. Swift, for his troubles, the U.S. Navy's reward for him was that he was denied promotion, and within less than 4 months after the Supreme Court of the United States decision, he was forced out of the Navy under their up or out promotion policy. Since he wasn't promoted, he was forced out of the Navy. Bush administration had Congress pass a new military commission legislation. Hamdan eventually came to trial in Guantanamo. Who appeared for him? A civilian lawyer named Charles Swift. And he did a great job. Hamdan was ultimately found guilty of providing material support to al-Qaeda, but was cleared of terrorism charges. Sentenced to 5.5 years of imprisonment by a military jury, got credit for 5 years he'd already been there. He went back to Yemen shortly after that. After leaving the Navy and after a year of teaching law, Charles Swift is now working as a criminal defense attorney in Seattle, Washington. And if you go to YouTube, you can see some of the recent talks he's given. Thank you very much for the opportunity to prepare and present this information.